We are coming together for this session at a very unique time. Here in Israel, it's almost Yom Ha'atzmaut. The sun is setting, and it is on Yom Ha'atzmaut that we particularly are thinking about the essence, the soul of the State of Israel and its relations with world Jewry, its partnership, its bonds with world Jewry. And we can't help but think about the core values of the State of Israel as they are expressed not only in the perplexing formula of the identity of the State of Israel as a Jewish and democratic state, but also in the specifics of the Declaration of Independence, which has presented the state in creation to be committed to the principles of liberty, justice, and peace, as taught by the Hebrew prophets, has promised full social and political equality to all, regardless of religion, gender, or race. And what is of particular interest to us, in addition to that, to us here at Hiddush, an organization which is a Israel Diaspora Partnership committed to religious freedom and equality, what is of particular interest and importance to us is, of course, the fact that the Declaration of Independence has explicitly promised that the State of Israel will uphold full freedom of religion, conscience, culture, education, etc., but freedom of religion and conscience. So we are meeting on the eve of Yom Ha'atzmaut, and it is the State of Israel that is of interest to us today, and we are fortunate to be able to hold this webinar under the joint sponsorship of Hiddush, of Ruach Hiddush, which is the acronym in Hebrew of Rabbanim v'Chazanim leChofesh Dat v'Shivyon b'Israel, Rabbis and Cantors for Religious Freedom and Equality in Israel, J-Plan, the Jewish Pluralism Legal Action Network, and the association, the American Association of Jewish Lawyers and Jurists. This is a great partnership that has been with us for some time, and I hope will continue for a long time to come. So with that in mind, today we'll be addressing the threats, challenges facing Israeli democracy in a very tachlis, in a very tangible, in a very concrete context, namely things that are happening now before the Supreme Court, that may be coming soon before the Supreme Court, that the court has already been ruling about, a constitutional crisis in formation, and one of the best people that could have spoken about this topic and about those constitutional challenges is our guest speaker, Professor Rivka Weill of the Interdisciplinary College in Herzliya, a world-renowned scholar in the field of law, a frequent teacher, visiting professor at the greatest law schools in the country, in your country, those who are in the US. Of course, not everybody's from the US, and I don't know whether Professor Weill has already taught in Canadian universities, but we are very grateful to Professor Weill for being with us and presenting the topic. To introduce the session, we have Peter Buxbaum, as I said, the chair of J-Plan, the Jewish Pluralism Legal Action Network. And if you would like to say a few words, Peter, you are on. You are almost on.
Unmute.
Yes, go ahead.
Thank you. It's a terrible thing for a judge to be muted. It's a hard one. I'd just like to welcome everybody to this webinar. It's very exciting to have the opportunity to hear from Professor Weill, having been fortunate enough to come across her work on the Barak Court and finding that maybe Israeli constitutional law is better grounded than our Marbury versus Madison in the U.S. by reading her. J-Plan is an organization I started with Uri and several others, Steve Greenwald, to try to get American lawyers more involved in what happens in Israel. I believe, I've come to believe, that we have a stake in what happens with Israeli constitutional democracy, because it will reflect on us here, and that as Jews who love Israel, we very much care about what happens there. At some point, we hope to have a link, or at least some information on how you would sign up with any of the organizations, the four that are co-sponsoring this program, Hiddush, Ruach Hiddush, the AAJLJ, and J-Plan, because we would like to continue the relationships that we're establishing under these crisis conditions. I would also mention that we're planning two more webinars, one on the 11th to be chaired by Ruach Hiddush, and we'll hear a little bit on that at some point later. A plague has happened in our house. Israel and America confront the coronavirus pandemic. And then on the 18th, we'll have another legal-oriented seminar, the Emerging Israeli Coalition, Death Blow to Pluralism, Opportunity for Change. We expect both of them to be at noontime. And you'll hear more about that, and there'll be further information that you'll receive about those two programs. And with that, I would like to turn it over to Steve Greenwald, the chair of the American Association of Jewish Lawyers and Jurists, to say a word about his group, and then to introduce our distinguished speaker.
Thank you. Can you hear me? Yes.
Yes, we can.
Thank you, Peter. Thank you, Uri. We are very pleased to be part of this coalition with Hiddush and J-Plan. The American Association of Jewish Lawyers and Jurists is a nationwide organization, as the name implies, of judges and jurists. We are an affiliate also of the International Association of Jewish Lawyers and Jurists, which is based in Israel. And what we do at the AAJLJ is to represent the interests of the American Jewish community and really the worldwide Jewish community on matters related to legal issues of all kinds and various kinds. And we do that work through educational programs that we run each year, through amicus briefs that we file in the courts. We filed numbers of amicus briefs in the Supreme Court on various issues and in the lower courts, through the programming that we do throughout the year. And in these difficult times, it's wonderful to have the opportunity to do this through our technology. So we're happy to be part of this and to be here. And it's my pleasure to introduce Rivka Weill. I think we've already heard quite a bit about Rivka, but I'll just do a little bit more formal of an introduction. Rivka is a justly renowned legal scholar, a graduate of Bar-Ilan Law School and Yale Law School. And at Yale, she earned both an LLM degree and a JSD degree, Doctor of Juridical Science. And in between that, she also picked up a degree in accounting, by the way, so remarkable record. Rivka is on the faculty of the Rasner School of Law at the Interdisciplinary Center in Israel, and has been a visiting professor at Yale Law School, Chicago Law School, Cardozo, and Columbia Law School. Quite a background and quite a pedigree. On top of all that, Rivka served as a law clerk and legal advisor to Chief Justice Aaron Barak of the Israeli Supreme Court. She's a recognized expert in the fields of constitutional law and comparative constitutional law and other areas as well. So I don't think we could have chosen a more qualified or better speaker to discuss current and urgent issues in Israeli constitutional law. And with that, Rivka, I'm going to open your remarks with a couple of, set the stage for your remarks.
Okay, so
all right.
I am on. In the meantime, I don't know if you've noticed, but I've been offline. So there is a problem with my connection to the internet. I'm hopeful that you are hearing me.
We're hearing you.
Okay, excellent.
Okay.
So I'm actually working on a hotspot. So it's a pleasure. It's a pleasure to be here today. I'm very thankful for the organization of the event. As Uri mentioned, this is a special time in Israel's calendar. We are transitioning from Memorial Day to Independence Day. And it's a time of great swings of emotion within the Israeli public. And I think that this state of emotions, of swings of emotions, is very characteristic of the Israeli public state of affairs these days with the current constitutional crisis taking place in Israel. So there are many unprecedented events taking place in Israel. Israel has held 3 election cycles within a 12-month period to try and end a political stalemate. And one of the thorny issues that prevented the formation of a government is the fact that we have a prime minister, Bibi Netanyahu, who has been indicted and accused of serious offenses, including bribery, breach of trust, and fraud. And there are many political parties in the Israeli political system who have committed to the public that they will not be part of a government if Bibi Netanyahu is the head. Now, public law considerations as well as moral considerations should have led Netanyahu to resign. But he refuses to do so. He argues, I'm innocent, and regardless, the public expressed confidence in my continued leadership. Now, Israel is based on a parliamentary system. And in a parliamentary system, the public does not elect directly the head of the executive. So Bibi Netanyahu cannot claim that he enjoys a direct mandate from the public to continue in office. At most, what he can claim is an indirect mandate to continue in office as a result of elections. Now, in the Israeli constitutional system, if the issue is not resolved in the political arena, people petition to the Israeli Supreme Court, sitting as the High Court of Justice. So already in November 2019, we had petitions to the Israeli Supreme Court, and the court did not rush to deal with the issue. The court at first stated, you know, there are looming elections, we don't need to decide the issue. You cannot actually fire the prime minister because he is a caretaker prime minister. Let's wait for elections. Okay, after the 2020 elections, we had again petitions to the Israeli Supreme Court asking the court to impeach the Israeli prime minister. And again, at first the court stated, you know what, the issue is not ripe for decision. Let's wait for politics to unfold. But now, these days, the issue is before the Israeli Supreme Court. And as we are talking, that justices are actually struggling with this question. Should the court impeach the Israeli prime minister? And I would like to suggest that the dilemma is the following dilemma. Which is the worst scenario from a democratic perspective? Is it to have an indicted prime minister serve as the prime minister in Israel, or having the judiciary impeach the Israeli prime minister? Now, this dilemma may seem foreign to American ears, because we have just witnessed the impeachment trial in the US Congress. So the Democratic Party was charging President Trump with using a foreign power to actually intervene in internal elections in the US. And the battle was fought and lost in Congress. And no one thought that you should actually try to undo the impeachment result in the courts. And no one thought we should do so First of all, because the Constitution assigns the power of impeachment to Congress, and regardless, this topic is considered a non-justiciable topic under US constitutional law. And that means that on prudential grounds, the court will not intervene. It will treat it as a political question assigned to a different branch of government. Now, when we think about one of the most contested decisions of the US Supreme Court in recent decades, the Bush versus Gore decision comes to mind. And in that decision, the US Supreme Court stopped the recount of votes in Florida. And even that decision led to major criticism and argument that the court has actually handed the elections, handed the victory to Bush. Think about it. This is merely an indirect intervention in election results. What we are actually now asking the Israeli Supreme Court to do is to directly intervene in election results and hand over that role of the head of the executive to someone other than Bibi Netanyahu. So how should we go about it? How do you go about it in the Israeli constitutional system? Okay, so in order to solve this problem, we should start with the constitutional text. Now, I assume that many of you know that Israel has undergone a constitutional revolution in the mid-1990s. In the United Mizrahi Bank decision, the Israeli Supreme Court declares that Israel's basic laws amount to Israel's formal constitution, and that the court has the power to invalidate statutes, to exercise judicial review over primary legislation. The court stated, here I'm joining forces with the Knesset to acknowledge that the basic laws are Israel's constitution, even though before the decision, we treated them pretty much like regular laws. So when I go and look at the constitution, I have to work with basic law, the government. And under basic law, the government, section 18 states that a majority of 61 members of the Knesset may decide to impeach the Prime Minister of Israel if convicted of an offense that the court defines as involving moral turpitude. Okay, this is a weird provision because we are a parliamentary system, and in a parliamentary system, supposedly on any day of the year, the majority of the Knesset may decide to oust the government, to oust the Prime Minister. Why wait for a conviction? And the answer is that Israel in recent years has adopted a constructive vote of no confidence system, which means that it's not enough that a majority votes negatively to oust someone from power. The majority has to also vote in a constructive way, in a positive way, in favor of a different government. Now, it's much harder, right? It's easy to vote negatively and oust the government. Very difficult to also vote positively in favor of someone else. But in the case of the conviction of the Prime Minister of Israel, the majority may simply vote a negative vote. Go home, we don't want you. Then section 18 continues that if the conviction is final, you can no longer appeal it. Then it's an automatic impeachment. He goes home, the government falls. In both cases, you don't need to go to elections. You can, the Knesset may express confidence in a new government, and if no new government enjoys the confidence of the Knesset, you go to elections. Okay, so this is the text. What do you do with it? What do you do in case of indictment? Should we interpret this text as exclusive so that in indictment situations, the Prime Minister may continue in office? Or should we interpret the text as dictating that, as dealing only with conviction and silent on the issue of indictment. This is an interpretation question. So I went and looked at the Knesset debates when enacting the basic law, to try and understand the subjective intent of Knesset members. So the Knesset was looking into the matter twice within a decade. And in both cases, the Knesset was adamant about the fact that prior to conviction, it does not want to allow the impeachment of the Israeli prime minister because of an indictment in an offense. And members of Knesset had serious reasons for that. First of all, they suggested that maybe an emergency will occur, and we will need to deal with that emergency. And we will need a leader who is not such a moral persona, but we will need him to deal with the crisis. And this is in 2001, this is in the 1990s. And then the Knesset discussed the fact that it does not want to place the judiciary in a position where the judiciary is the one to impeach the Israeli prime minister before final conviction, because it's not good on institutional grounds. And then the Knesset also stated, and I'm talking about members of the Knesset, that, you know what? There would be such an incentive to indict the Prime Minister of Israel if indictment can lead to impeachment. Let's wait for conviction. So they were worried about the integrity of the prosecutorial discretion in Israel. Okay, so I have basic law, I have text, I have Knesset debates, but this is not the end of the matter in Israel's constitutional law, because the Supreme Court uses purposive interpretation. We in Israel, we don't have serious debates between the Supreme Court justices. Do we want to be textualist? Do we want living constitutionalism? Is it about, what is the best way to interpret the Constitution and the statutes? No. It's not like Scalia, Scalia, he's no longer with us. But it's not like the debates between Scalia and Breyer and the whole action around it. In Israel, it's purposive interpretation, which means you look at the text and the justices ask themselves, what interpretation will best promote the values of the Israeli constitutional system as Jewish and democratic? This is quite open-ended, right? What will best promote? Okay, and if this is the question that I'm asking myself, then the court will take into account the fact that there is a whole line of judicial decisions that state that even when the law sets qualifications for serving in office, or even when the law states conditions for removal from office, this is bare minimum. And the court can add qualifications, can add conditions to protect the public faith in the integrity of the executive branch. Now, we would have thought maybe public confidence is a subjective measure, right? Maybe we should look at the 2020 election results and understand, is the public, do we have public confidence? Do we not have? No. It's an objective standard. What do the justices think would compose public confidence in the executive branch? Okay, so to fill the vacuum or to fill the silence of the legislature or the Constituent Assembly, I looked for complementary arrangements. Maybe somewhere else in the law, I can find an answer to my dilemma. Now, if I were a presidential system, if Israel was a presidential system, then you would typically have impeachment mechanisms. And that would entrust to the majority or a supermajority of the legislature the decision to impeach the president between elections for high crimes, misdemeanor. Israel is a parliamentary system. And what's interesting is that also in parliamentary systems, such decision is usually trusted to a majority of the legislature because the prime minister comes from parliament and enjoys parliamentary immunity. And you cannot indict a prime minister in parliamentary systems, typically, if you do not remove the immunity. Israel's law is different. In recent years, in 2005, the Knesset changed the default mechanism with regard to immunity. Once, members of Knesset had immunity unless the Knesset removed that immunity. Today, the default is that members of Knesset do not enjoy immunity unless they request immunity and are granted such immunity. And I'm talking about procedural immunity, the ability of the prosecution to actually indict a person and try the person in court. And the reason why the Knesset changed the law in 2005 is that the court intervened in decisions on immunity. Now, it's a very big difference to decide, for the Knesset to decide to take away from someone an immunity that one enjoys. Right? This is a difficult decision, right? A very heavy decision. It's a totally different issue to decide not to grant immunity that you do not have as a default. And since the law changed on the subject, there was only one case that a member of Knesset enjoyed immunity. And Bibi Netanyahu did not even ask for immunity. Okay, so immunity is not solving the problem. So the court is left with the issue. Text alone is not enough, right? A legislative intent is not enough. Comparative law doesn't give real guidance. We are sui generis in that perspective. Okay, so what do I do? Maybe I should make an analogy from the way we treat ministers in Israel. So with regard to ministers, we have common law decisions that if a minister is indicted with a serious offense, he must resign or the prime minister must fire that minister. But you cannot apply the analogy in a simple way, because if a minister goes home, the government continues in power. But if the prime minister goes home, then the entire government falls in Israel. And this is the decision of the basic law. The basic law states that if the prime minister dies, he's permanently incapacitated, he resigns, he's fired for any reason, then the entire government falls. And the reason is that the basic law assumes that if you change the identity of the prime minister, you cannot assume that his or her replacement will enjoy the confidence of the Knesset. So you must actively check, do I have the confidence of the Knesset? Do I not have? And actually, this position is supported by history. When Tzipi Livni replaced Ehud Olmert, she did not gain the confidence of the Knesset. When Shimon Peres replaced Rabin, he didn't enjoy the confidence of the public. So the basic law assumes the identity of the prime minister is crucial. The fate of the government depends on the identity of the prime minister. Okay, so the court is left with pure balancing of interest. It must take the text into account. It must take legislative intent into account. It must also take into account purposive interpretation, and in the end, use a balancing of interest test. And here the court will ask itself, okay, what's the interest at stake? On the one hand, if we have an indicted prime minister in office, then, how does it look? It's bad for the international reputation of Israel. It's bad inside Israel. What will the simple citizen think, right? If the prime minister can be an indicted person, then, why shouldn't I break the law? We should be worried about conflict of interests. Any decision the prime minister makes, is he actually thinking about the public good? Or is he thinking, how does it help me in court? So there's serious considerations why to argue that, you cannot be a prime minister if you're indicted. And this is why I've stated in the beginning that from a public law perspective, from a moral perspective, Bibi Netanyahu should have resigned. But on the other hand of the balancing dilemma, from the court's perspective, is the question, how does it look? And what's the democratic implications of the fact that it is the judiciary that impeaches the Israeli prime minister? And we have to understand that there is a big gap between indictment and conviction. Because when the Attorney General of Israel decides to indict, he only has to come to the conclusion that there is a reasonable possibility that the prime minister will be convicted in court. This is the standard for all people. But when it comes to conviction, the court has to be convinced beyond reasonable doubt that the person committed the offense. So it's a big difference, right? Reasonable possibility of conviction, beyond reasonable doubt that you committed an offense. So to base impeachment of the Israeli prime minister based on reasonable possibility of conviction, that's very problematic. And I would argue that for institutional reasons, the court should not impeach an Israeli prime minister before final conviction. Now, we should also understand that the whole basis to impeach the Israeli prime minister is a common law doctrine of public faith in the executive branch. But public faith is needed also vis-a-vis the judicial branch, right? The judicial branch, in the end, we tend to forget, but in the end, it's a weak branch. It does not enjoy the power of the purse. It does not enjoy the power of the sword, in the words of the American founders, right? The Federalist Papers, right? It depends on public trust, on public's confidence. And we should be worried about public confidence in the judiciary if the judiciary impeaches the prime minister before final conviction, because also the court has an institutional stake in the case at hand. And we should also be worried about the fact that the public may not have confidence that the judiciary will be able, from an institutional perspective, to acquit the prime minister if the judiciary is the one impeaching the prime minister first. And we don't want to be in that situation. So people suggest, you know what, but it's against rule of law principles, right, to have an indicted prime minister in office. And I want to suggest that in a very deep way, the fact that you can have a prime minister who is indicted and is before the court is actually a manifestation of rule of law principles. That actually Israel is a country ruled by law and not by people. You have to compare to the US, right? In the US, the Department of Justice opinion is you cannot indict a sitting president because that would go against separation of powers. That would actually injure the energy in the executive branch. Israel's position is different. Okay, so, but one may ask me, wait, but if the judiciary impeaches the Israeli prime minister, then that will not lead to the fall of the government. We have a caretaker government in place, right? The equivalent of a lame duck president, right? We are after elections. Bibi Netanyahu is just a stand-in for a new government. The government has already been ousted. You know, what's the big deal? We will only declare that, you know, he cannot be in office, and that's all. And beyond a textual answer, which I have, I don't want to go into it now, I'm in the Q&A, we can do it, but beyond the textual answer, I want to look at it from a historical perspective. And I want to take you back to 1977. In 1977, we have Prime Minister Rabin in power. And he is a caretaker. He's in a caretaker government situation. Now, to anyone familiar with Israel's history, 1977 is the watershed year. This is the first time that a right-wing political party comes to power, Until then, we have only a left-wing party in power. Before election, the Attorney General of Israel at the time, Aaron Barak, approaches Rabin and tells him, you know what, I decided to indict you. Why indict? Why indict? And Aaron Barak tells, the Attorney General tells Rabin, listen, you may have forgotten, but you have a negligible bank account in Washington. From the times that you were ambassador in Washington, $20,000 you have over there. This is against the currency laws of Israel at the time. I'm going to indict you. That night, Rabin announces on TV, I'm not running for re-election, and the result is a change in a major watershed election that leads to the rise of Likud to power. And this story tells you that even during caretaker times, intervention of the legal system in the identity of the head of the executive is something that we should be very worried about from a democratic perspective. I'm not going to speak more about indictment. I want to talk about the second topic, and that is the open defiance of a judicial opinion by the Speaker of the Knesset. But during the Q&A time, I would be happy to talk more about Benjamin Netanyahu's indictment. And as I go to talk about the Speaker of the Knesset Defiance Act, I want to make sure that you hear me and everything is fine.
We can hear you.
Everything is okay? Okay, excellent. Okay, so I will call the decision that I'm going to discuss now the Yuli Edelstein decision, after the name of the Speaker of the House. But you have to understand that the decision is not called Yuli Edelstein. It's actually the Movement for Quality Government in Israel. But the Movement for Quality Government is a public petitioner, and there are so many important decisions in Israel's constitutional law that are named after the Movement for Quality Government that to distinguish, I must call it the Yuli Edelstein decision. But it shows you something about Israel's constitutional law. Right, that any public petitioner can raise an issue of public concern to the court. You don't need a case and controversy, right? You don't need a specific petitioner. Okay, so we have the Yuli Edelstein decision. And the decision is unprecedented in two substantial ways. First of all, you have a court intervening in internal proceedings of parliament, dictating the time of vote for the replacement of the Speaker of the Knesset, right? Think about it. The rainmaker of the Knesset, the most important position in the Knesset, right? Who is the Speaker of the House, the one who decides the legislative agenda, decides the time of vote. So the court intervenes, dictates the time of vote for his replacement, and not just that, the court makes a decision within 24 hours of hearing the sides and dictates the vote within 48 hours of the decision. What's the urgency? What's happening here? Okay, so this is one side, unprecedented worldwide situation, a court intervening in internal parliamentary matters on the most crucial issue, a vote on the Speaker of the House. And then you have an unprecedented event, watershed-ing event in another sense. So you have this important public figure, the Speaker of the Knesset, openly defying a court order. He waits until the expiration, until almost the end of the expiration of the deadline for removal. And he announces in the Knesset, you know, I have a conscience and I cannot, I can't obey by the court decision, so I resign. Now you have to understand, Israeli governments are not always happy to abide by judicial decisions. So sometimes Israeli governments drag their feet, they ignore a decision, but never did we have a situation of open public defiance of a court order. Okay, so did everyone go crazy? What's happening here? So let's go back and look at the context in which the decision is given. So we are in COVID-19 times, right? we have a government in Israel that is a caretaker government, right? It's a government after elections. It does not enjoy democratic legitimacy anymore. It's a special caretaker government. 3 cycles of elections and no government yet. And you have a government regulating by decrees each day and new regulations, emergency regulations, infringing greatly on civil human rights. Okay, and into that scenario, this case fits in. So after the election, the president of Israel, Rubi Rivlin, meets with the political parties, and 61 members of the Knesset recommend that he should assign Benny Gantz, the head of the blue and white bloc, the task of forming a government. Okay, so many Israelis sighed in relief. You know, we have Bibi Netanyahu since 2009. It's about enough. Right? The children do not know of a situation in which, you know, you can have a different prime minister in a democracy. Right? If you look at the Y agreement pictures, you see Arafat, you see Hussein, you see Clinton, you see Bibi Netanyahu, right? The only one who is still relevant is Bibi Netanyahu. So people sighed in relief. You know what? 61 members of Knesset recommended Bibi for the role. Maybe finally democracy works. We'll see someone else in power. But Benny Gantz is put in a hard spot, difficult spot, an insurmountable obstacle, challenge. He has 61 members who are adamant about the fact that they do not want Bibi Netanyahu as prime minister. Okay? But they are not cohesive enough to agree to sit with each other. So you have a political alliance that is composed mainly of Arab political parties, that some of them stated that they are not going to sit in government with Benny Gantz, who was the chief of staff and is responsible for some of the harsh treatment against Palestinians. And then you had some members within the blue and white bloc who stated, we are not sitting with some of the members of the political alliance because we believe that they are supporters of terrorism. Okay, so Benny Gantz, what does he do? He works parallel, in a parallel mode. On the one hand, he negotiates with Bibi Netanyahu and with the Likud to form a unity government. But on the other hand, he wants to take control of the Knesset. But he has a problem. In the Knesset, he finds Bibi's guard, Yuli Edelstein, the Speaker of the House. So the Speaker at first refuses to enable the formation of Knesset committees until we reach a consensus on the size, membership, what have you. Then he applies emergency regulation, right? COVID-19. He applies COVID-19 regulation to the Knesset, to the committees. You cannot convene more than a certain amount of people in the same room. He does state in the letter, you know, I don't want to interfere with the work of the Knesset, but you know, it's, you know, you're talking from both sides of your mouth. Okay, and in addition, there are 61 members of Knesset who demand a vote on his replacement, and he refuses to bring the vote in front of the Knesset. So what do you do in Israel? Right? One option is obviously to go into a physical fight, right? It also has happened in Israel. But they go to the court, right? They cross the street and they file a petition. Okay. Now, maybe the most important contribution of the decision is what's not written in it, is in what's achieved in the shadow of the petition. Because in the shadow of the petition, miracles happen. Suddenly, Knesset committees form, the Knesset starts operating. The only thing left on the table for the court to decide is the time of vote of the new Speaker of the House. Okay, so the petitioners argue, listen, Yuli Edelstein is acting in an unreasonable way, in an undemocratic way. 61 members of Knesset, the last time we checked, it's a majority, it's an absolute majority from 120 members of Knesset. He is refusing a vote when the majority requires a vote. So it's undemocratic. He has a personal stake in the matter. He doesn't want to be replaced. Okay, so he's exercising discretion in an unreasonable way. and allow us the vote. Yuli Edelstein argues, listen, I'm within the letter of the law. According to the bylaws of the Knesset, I can hold elections on a new Speaker of the House at the latest when the new government is sworn into office. So I'm within my authority. And I have substantial reasons to delay the vote on my replacement. First of all, this will prevent the formation of a unity government in Israel. In addition, the new speaker will allow contested, disputed legislation to pass. Now, these are code words. If you read the decision and you're a foreigner and you do not follow closely Israeli news, you would not understand, what is it talking about? What kind of contested legislation? If you are an Israeli and you read the decision in 20 years' time, you will not know what the court is hinting to. What's contested legislation? I will tell you in a few minutes. Okay, so he argues, if you have a new speaker, contested legislation will pass. And then he says, we are a parliamentary system, and a hostile speaker is unhealthy in a parliamentary system. It will not allow proper cooperation between the legislature and the executive. Okay, so the court has to decide the matter. Now, the court is not concerned with the question, does the court have authority to decide the issue? The court is not worried about the question, is it justiciable, right? Is it a political question or not? The court has already a common law doctrine at its disposal. Already in the past, in the 80s, the court has ruled that the court will intervene in internal parliamentary matters if there is a great danger to the most basic tenets of democracy, of the parliamentary system. Right? So if there is a great danger, the court is there to be the guardian. So the court applies this test to the case at stake. And the court states, okay, I agree with you, Yuli Edelstein. You are right. You are within your authority. According to the bylaws of the Knesset, and I will read to you the bylaws. So according to the bylaws, the language is as follows. The Knesset's speaker shall be elected no later than the date on which the Knesset convenes to establish the government. So you can wait with the vote until the new government is sworn into office, explicit language of the bylaws of the Knesset. But the court said, okay, you have authority, but you are exercising your discretion in an unreasonable way. The court stated, you have a narrow range of discretion because it's a caretaker government after election, you have a stake in the decision, and you are preventing the majority from prevailing. And the court stated, I'm not worried about a hostile Speaker of the House because I'm presuming that the Speaker will be impartial, right? Have you heard of a Speaker who is impartial, right? Speaker of the House, right? Nancy Pelosi or Mitch McConnell, right? Okay, so I'm going to presume that he is impartial. And you know what, Yuli Edelstein, and this is my words, you know what, Yuli Edelstein, you're a confused man. Why are you a confused man? Because you do not understand the parliamentary system. In a parliamentary system, and this time it's the court's words, in a parliamentary system, the Knesset is not the chair band of the government. The most important institution is the Knesset, and the executive is less important. It is derived from the Knesset. Okay, this is the decision. The decision actually exposes a major principled controversy between the speaker on the one hand and the court on the other. And the principled dispute is about the nature of the relationship between the executive and parliament in a parliamentary system. According to the court, we should encourage, we should welcome friction, adversarial relationship, because that will enhance separation of powers. But according to Yuli Edelstein, and this is now me developing his argument, systems, countries choose a parliamentary system because they want cooperation. They do not want a confrontation between the branches of government. In a presidential system, it's more common to have one political party controlling the legislature and another political party controlling the president, because the parliament cannot typically oust the president in a presidential system. So you can still have them working in a hostile relationship, but being both of them together in power. In a parliamentary system, this is not feasible. If you have constant hostile relationship between the two branches, you go to elections, you vote no confidence, the prime minister can actually dissolve the Knesset. So this is actually the nature of the principled argument between the two parties. Yeah.
Can you hear me? Okay. We're getting near
I didn't.
time. If you could sort of sum up, because we have questions that are piling up for you.
Yeah, definitely. Definitely. So the most interesting part is, why did the court hurry to decide that? Why did Benny Gantz rush to the court? And this is actually the most important part of the story. So why did Benny Gantz run to the court? And the answer is that he wanted to pass contested legislation. And that contested legislation was to amend the Constitution to actually provide that an indicted prime minister cannot serve in office. Now, both sides to this legislation argue based on rule of law principles. Those in favor of such legislation argue, this is obvious, it's just clarification, that an indicted prime minister cannot serve in office. Those against such legislation argue, you're changing the rules of the game in the middle, you are preventing the popular will from prevailing, and this is against, this is specific legislation intended to harm Netanyahu, you cannot pass it. But Benny Gantz needed this legislation as a bargaining device vis-a-vis Netanyahu, and also to change the entire political arena. Maybe political parties will agree to join him now that we have such amendment. So this is Benny Gantz's game. Why did the court cooperate? Right? Why? So some would argue that maybe the court is political. Maybe the court wants Benny Gantz and not Bibi Netanyahu in power, right? This is not my argument. I'm not arguing that the court was political. The court was hurried to intervene because the court wanted to prevent a coup d'etat. A coup d'etat. Now, why would the court worry about a coup d'etat? So we know that Netanyahu is in power. We know for many, many years. We know that there were 61 members of Knesset demanding the replacement of the speaker, and the speaker was not allowing it. So all this added. But you have to understand also the context in which the court gave the decision. You have the black flag movement in the streets in front of the court demonstrating Bibi Netanyahu is dangerous to democracy. And, you know, we should even break the law to preserve the law. These are dire times. We should play even out of the rules of the game. You have at the same time op-eds in the newspapers suggesting that the coup d'etat occurred, that the Knesset is not operating. You have no Knesset committees. You are not replacing the speaker. A coup d'etat is occurring. This is why the court is hurrying to intervene. And then I'm ending with the last unfolding drama. What's so interesting is that some of the winners in the court became the losers in the political arena. And this is primarily Yair Lapid and Yesh Atid. What happens is that Yuli Edelstein waits until almost the end of the 48 hours because negotiations were taking place. Bibi Netanyahu threatens Yuli Edelstein, threatens Benny Gantz. If you do not place yourself as the next Speaker of the House, no unity government is formed. So Benny Gantz agrees. That leads to the falling apart of the bloc of blue and white, because the Speaker of the House was intended to someone else in Yair Lapid's bloc. Now, the court's intervention turned out to lead to a major realignment in the political sphere, to actually the falling apart of the blue and white bloc. And in retrospect, it turns out that there was no coup d'etat to prevent. So in a sense, had the court known what we know today and what Yuli Edelstein probably knew in real time behind the scenes, maybe the decision would have been different. So these are interesting times, and I will take Q&A.
All right, that's quite a lot you've told us and given us. I would like to buy the film rights to that whole story myself. So, but we do have questions. Uri, are you going to present the questions?
The first question is sort of technical. You have referred to Israel's constitution and you have alluded to basic laws. And the question is, so what are those basic laws and what's the difference between a basic law and a regular law? Who determines that a law is a constitutional basic law?
Okay, so basic laws in Israel are typically enacted just like any other law. Some of the most important basic laws in Israel passed by simple majorities. Actually, the two basic laws that led the court to announce that we have a constitutional revolution passed with slim majority support. Some of the basic laws later on demand a huge majority, not even a huge, 61 members of Knesset, sometimes a little bit more, to replace them. Now, the basic test to decide whether it's a basic law or not is actually the title. Is it titled basic law or not? There is a hint that maybe the court will one day intervene also based on substance and actually decide that some basic laws do not deserve to be treated as basic laws. And this is the big question of the unconstitutional constitutional amendment doctrine. Right. So it's in the background, and one day it may become part of, majority opinion.
Maybe if I could add just a minute of context, of course, those who read Israel's Declaration of Independence will see that there was a naive belief that within 6 months from the founding of the state, the Knesset would adopt, or the constitutional body that is the Knesset, would adopt a full-fledged constitution. That is in the language of the Declaration of Independence. That didn't happen in 6 months, didn't happen in 6 years, didn't happen in 60 years.
Right.
Personally, I doubt very much that it will happen. But in 1950, the Knesset realized that that wasn't going to happen anytime soon and passed a resolution that introduced the concept of basic laws as coming together to form ultimately Israel's constitution. So the next question has to do with some unclarity as to when is the prime minister removed as a result of the indictment or the legal proceedings, and when is it the discretion of the Knesset? There was a question which I think alluded to maybe not realizing that in the case of a final conviction, the removal of the prime minister is mandatory. So maybe you can recap that again.
Okay, so in general, there was a great dispute in the Knesset whether we should adapt a provision of automatic removal upon final conviction. But in the end, in the 2001 basic law, the Knesset decided, by the way, against a legal opinion, against the Ministry of Justice opinion at the time, that if it's a final conviction, then, and you can no longer appeal, then the removal is automatic, no discretion to members of Knesset. But before final conviction, so that no further appeal is possible, when you have only a conviction, but it's not final because you can appeal it, then it depends on a majority of members of Knesset.
There was a follow-up question about the basic laws, and the answer is very simple. Yes, the Knesset may amend basic laws, except the basic laws include provisions and conditions as to how and with what kind of a majority they can be amended. but they can be amended by the Knesset. Maybe Professor Weill, you'll say just a word about this dual hat that the Knesset has as a result of that situation.
Okay, so there's a big question, there's a big theoretical question. What justifies the fact that the same body, the same institution, sometimes enacts statutes and sometimes enacts basic laws, and they are enacted via the same procedure, and nonetheless, we see a difference in hierarchy, that basic laws are higher in hierarchy than regular laws and may lead to the invalidation of regular laws. And it's astonishing also taking into account that the basic laws can be passed by simple majorities. And this was part of the great debate between the justices in United Mizrahi Bank. So United Mizrahi Bank is pretty much the equivalent of Marbury versus Madison in the US. But in the Marbury versus Madison instance, you had a formal Supreme Constitution that no one doubted. There was only the question of judicial review. But in the Bank Mizrahi decision, the court actually had to do all steps at once, declare that the basic laws are a constitution. Not only they are a constitution, they are supreme. And not only are they supreme, we also have the power to invalidate statutes based on the basic laws. So what the theory that may legitimize it, we have different opinions. Aaron Barak's opinion is one of the opinions, and it is the opinion that the Knesset actually has two hats. And when it sits in its hat, in its capacity as a constituent assembly, it is able to do more normatively than when it sits with its hat as a regular legislature. Now, in a way, Barak tried to suggest that we, all political players, understand that it's a special function, all agree that the basic laws are supreme, all agree that the Knesset is the constituent assembly. There are many assumptions behind this decision.
Well, there are a couple more questions, and I think that probably you'll be able to answer them briefly. One is, when Bill Clinton was discovered to have committed a wrong, many thought he should resign. But though impeachment was not appropriate to remove a duly elected leader, but thought that impeachment was not appropriate to remove a duly elected leader. In Israel, isn't the onus on Knesset and the electorate to do the right thing? And if they don't, that is the democratic decision. Better than having a court remove the executive. Political opponents of Bibi may want him gone, but the remedy is democracy. So in a way, it's going back to your core theme, democracy versus court intervention. Or not democracy, but political action versus judicial decisions.
Right. So I would agree, first of all, with the bottom line, that I think that unfortunate as it may be to many of us, absent a democratic decision and taking into account the text as it stands, then it's very problematic on institutional grounds for the court to intervene. Now, the Knesset did have options this time around to try and act differently. Had the 61 members been able to form a coalition, right, be cohesive enough to overcome differences, then we would have faced a totally different scenario. In a sense, what I was hinting is that maybe even if the court, but hindsight is always perfect, right? But if the court maybe have waited with its intervention in the Yuli Edelstein decision, maybe we would have had more time for politics to take place, and we wouldn't have seen the falling apart of the blue and white black. But ultimately, I agree that at this stage, unfortunate as it may be, we should allow democracy to work. And the Knesset doesn't have the power. The Knesset has the power to express confidence, so it can decide not to express confidence in the unity government now, in which case we will go to elections, but it's a political decision. But we do see such heated debate because the expectations of the public from the court are so great. The court has been the miracle of Israel's political and constitutional life, right? Where before a constitution was declared, then, you know, it was the court actually protecting in a common law way civil rights in Israel. And then the court built a whole, you know, from with not a lot at its disposal, the court was able to build protection for human rights. So the expectations are that the court would be the wizard and would just solve for us the problems. But I think this time it's beyond what we should expect of a court to do.
What were the other questions?
Sorry?
But go ahead with the questions that are.
Okay, the last question, sort of along similar lines. I understand the reluctance of the court to cause the downfall of an elected prime minister or to overturn the results of the election. However, since Israel does not have a presidential system, a ruling preventing Netanyahu from leading the government would not overturn the election results.
Right. I think making such an argument is actually not taking into account the role of political parties in presidential and in parliamentary systems. Because when the public goes to elections in a parliamentary system, the party looks at who is the head of the political party, who is the candidate of the political party in the coming elections. And especially as we saw now, and not just now, already quite a few election cycles, not only does the Likud designate, you know, who is going to be the next prime minister of Israel, but other political parties commit in advance, who are we going to support as the next prime minister of Israel? So ignoring that dynamic is problematic. Now, there are many arrangements in the basic law that brings us to some kind of a hybrid system that is not purely parliamentary and is not, definitely not presidential. But the whole idea that the basic law itself identifies the prime minister is so important that his or her replacement must lead to the fall of the government. This is something that is a remnant from the period in which we had direct elections to the prime minister of Israel. And we see that it actually aligns with the way that politics works de facto. And by the way, when the Knesset was discussing the desired treatment of an indicted prime minister, the Knesset also toyed with the idea that maybe the next in line within the political party should take the role of the person who was indicted. And the Knesset ruled out it. It decided that it's not a good idea because we cannot assume that you will have a coalition if the next in line will be the prime minister.
Steve?
Are there any? I know, Rivka, that you've written a great deal about the legacy of Aaron Barak. I'm a great admirer of his. But aren't some of the issues that you brought up today, could they be thought of, could they be deemed or traced back to the fact that there is no such concept as a political question in the court, in Supreme Court in Israel, High Court in Israel? Right? A lot of, as you pointed out, many of the issues that come before the court in Israel would not be dealt with by our court, the Supreme Court, because they would deem it a political question. So, and it seems to me that some of the issues you're talking about are politically, are you know, essentially political questions. So I'm asking you in the context of the legacy of Aaron Barak,
Right.
whether whether that's the right decision for Israel as well, to not have a political doctrine bar, let's put it that way.
And giving Barak the last word, which is very appropriate, I think we'll probably have to come to an end of this session.
Okay, so Uri, but do you want me to answer?
Yes, definitely.
Okay. So I will take this question and put it in a broader context. The whole scenario unfolding before our eyes is totally colored in the colors of President retired Aaron Barak. because standing, right? You would not be able to see
Standing
even,
too.
the movement for quality government, if not for Barak's decision expanding standing to the Supreme Court. You would not all issues would be justiciable. There would be a political question doctrine. Reasonableness is the standard to intervene in the discretion of the Speaker of the Knesset is Aaron Barak's work. Not just that, intervening in internal parliamentary matters is a decision of Aaron Barak from the early 1980s, in which actually the court laid the grounds, but did not intervene in the case at stake. It was a Sari decision. It was the timing of a vote of no confidence in the government. And Aaron Barak lays down the test, but does not intervene. And their decision, the decision that actually a minister who is indicted should go home. This is the jurisprudence of Aaron Barak. So the entire, in a way, all the different blocks of Aaron Barak's heritage to us, ours in one way or another are affecting this unfolding drama. So, the court may intervene and decide, you know what, I'm applying the same doctrine that I apply to ministers to the prime minister, but that would be a major upheaval.
All right.
The court can back a little bit, can back out and just, treat the prime minister as sui generis. And this is what I'm arguing the court should do.
Well, I think
you're suggesting go even far, go even backwards and look again at, political question doctrine and just state, this is not for us to decide.
Yeah,
so the court.
I didn't suggest that. I was raising the question about which we can perhaps have another session with you about, which is Barak's legacy. I'm a great admirer of Aaron Barak, and but I think there are questions that can be raised about his legacy, and whether this takes us, meaning the Israeli system, in the right direction or not. So I think we should save that for another day. And I think with that, we should wrap it up and thank Rivka. I mean, it was a fascinating discussion. I think I say that for American lawyers trying to figure out or American generally trying to follow and figure out the legal system in Israel and what's going on is head spinning. That's the word I use. So, but I think you've helped bring us some clarity today, and I think we should think about another program that would continue this discussion. So, Michael, do you want to talk about the upcoming, the next webinar we're going to have? Or Peter, Michael, I think was going to do it. Michael?
I'm not sure that he's on, that he made it to the...
So we just put up,
huh?
You just put up the...
yeah,
hello, hi, Corey, I'm here.
Oh, good, go ahead, then just...
Come on, Michael.
I just unmuted myself.
Next session.
A little time to unmute. The next webinar is scheduled for Monday, May 11th at 12 noon. Its title is "A Plague Has Appeared in Our House, a discussion of the medical, social, religious, and political impact of COVID-19 pandemic on Israel and the American Jewish community." It will feature a prominent microbiologist in Israel, Dr. Alon Moses, the deputy mayor of my own town, who really took charge of the COVID-19 event. Not so much an event, but a plague, namely Eli Katz, and finally, political comment by Dov Zatan.
Right.
So I want to add my thanks to Professor Weill, who certainly has clarified in a really such an impressive way two major complex challenges that have been facing Israel in recent political upheavals and are still, to a great degree before the court and under dispute. So this is wonderful, and I want to add my thanks. And the session that's going to follow it, and just to correct one misunderstanding. The session that's going to follow that on May 18th, the emerging Israeli coalition, Death Blow to Pluralism or Opportunity for Change, is not going to be lawyers-oriented, legal-oriented, but is going to be incorporating facts on the ground, politics, Israel-diaspora relations, and issues of religion and state that are implied or explicitly referred to in the coalition agreement, and what's going to happen next. So I hope that those of you who are lawyers will join us, and those who are not lawyers will join us. Two great upcoming webinars, and I will look outside the window. It's already dark here. So Chag Sameach, happy Yom Ha'atzmaut, happy Day of Independence.
Yes, and thank you again to Rivka. And I would like to do another one with you on the legacy of Ron Barak. We made this new program too. So thank you all very much. Thank you, Uri.
Thank
you
all.
so much for this opportunity. And I'm sorry if the line was not great.
What?
Okay, it's the network, you know, the band.
Oh, no.
Okay.
What didn't work? It wasn't a problem. All right.
Okay, excellent. So bye-bye.
Hello.
Bye-bye.